number 138, People ex rel. Allen v. Yelich. Good afternoon, counsel.
Good afternoon. My name is Michael Cassidy from Prisoners Legal Services of New York on behalf of appellant Eric Allen. I'd like to request 2 minutes, please, for rebuttal.
You may, sir.
Thank you. Mr. Allen seeks concurrent out-of-state sentence credit against a previously imposed and undischarged New York State sentence,
Counsel,
the time that he served in
Counsel,
New Jersey.
If you could clarify a little bit of the facts for me here. As I understand it, this defendant, your client, is out on PRS. He absconds, he commits a crime in Jersey, he's sentenced.
Yes.
And in my mind, there are two things now going on in New York. There's a violation of the PRS, in which case he's going to get some type of incarceration, right? And then there's the unfinished PRS term, right?
Yes.
The Jersey sentence, as I understand it, again, I'm not 100% clear, but the Jersey term of incarceration is run concurrently with the time he gets for the violation in New York?
With the undischarged New York sentence, which includes
Which is
the
essentially
period
a
of
penalty
PRS
for the
that he owes.
violation, right? So he violates and they put him back into prison for a certain amount of time.
Yes.
And that is offset by the Jersey time. So let's just give an example. Let's say it was 2 years here and the Jersey sentence was 2 years. Those 2 years would run concurrently.
Yes.
And now what you're asking for, as I understand it, is the Jersey sentence of incarceration to be run against the unexpired PRS time?
Yes, because he had served when in the determinate sentence situation, there's the determinate prison term, and then there's also the PRS
Right.
as part of that. So at this point in his sentence, he was owed the PRS time, which becomes his new maximum.
Let's say,
term that he
in
could
my
be held.
hypothetical, that 2 year sentence in Jersey, 2 years incarceration on finish the sentence here, and you have 18 months left on the PRS. Would you run them all together? So you get the 2 year incarceration term in New Jersey covers both your incarceration that you get as a violation and your unfinished PRS time.
It would. I
But
mean, had
what
he been
kind of-
sentenced here in New York, if he committed the crime on this side of the Hudson River and been sentenced here, there probably wouldn't have been a time assessment anyway. He would have served that new term. That would have been applied against the PRS that he owed.
The time that he serves in New York, is that for the violation being he goes to New Jersey and commits another crime, or is it because he absconded?
That, I'm not certain how.
I thought it was
how
the
the
absconded. I thought,
parole,
yeah, I thought
considered
2013,
that.
right.
Because what I'm starting with is the policy of getting credit for all of this essentially washes out any type of penalty for the other, right? So you've got a sentence in New Jersey that's going to run concurrently with a sentence being finished in New York and concurrently against a PRS term that he violated it by absconding. So by absconding and committing a crime in New Jersey, you get to do this term in New Jersey and wipe out your entire New York sentence at the same time.
Well, as running concurrently with what was left owed on the New York sentence, which at that time was the PRS, he would serve both of those at the same time, which would have happened had he been sentenced here as well.
So you're not arguing, as I understand it, again, just to clarify your position, that that New York was required to comply with what you see as New Jersey's desire to run all of this concurrently, right? In other words, you're not saying that what New York did was illegal. You're just saying it wasn't fair.
That's a big part of the argument, that it was fundamentally unfair not to run that time and credit that time here. Less that I mean, there's no constitutional argument that New York, the department, would have to run that time, but it's sort of the reverse, looking at, well, why shouldn't this time be run? And based on the case law in the in the courts, particularly in the definite sentence situation, which there's a long history and line of precedent regarding the definite sentence cases. The way the department has sought to distinguish those cases, I mean, there's no reasonable distinction on that. The department is denying the credit.
But isn't there a reasonable distinction between the courts of our state deciding what is the fair and proper way to run these sentences and having another state make that determination? So, because as I understand it, and correct me if I'm wrong, and maybe I'll ask your adversary the same question, this is in fact how, when New York State wants to run something concurrently to another state, generally they send the defendant to that other state and let the sentence run, and then if there's more time, they come back.
Right, it would work both ways.
Right. So what's unfair about letting the state of conviction, if you will, make its own determination as to how its sentence is going to run, and if they want to run it concurrently, send it to the other state?
Right, well, we believe, we invited the court to look at the Hall decision as an example of
Yeah, but Hall, it was clear. The state court and the federal court were expressly said that they wanted the same thing.
Right, but I would argue that the important principle to take from that case is not this dual situation there, but the idea that, wasn't, New Jersey agreed that its sentence could run concurrently with the New York sentence. It was through no fault of Mr. Allen's that he didn't get returned to New York. New York knew where he was. They knew what was going on.
Well, could
They had a warrant
Mr.
against him
Allen have
there.
asked to be moved to New York?
But he had no authority or power to compel them to bring them back, and they chose not to act on the warrant. That's one of the troubling parts of this case, which I believe contributes to the fundamental unfairness in it, and that they knew where he was, they had the
Well,
warrant,
maybe they
could
didn't
have
want
acted
it to
on
run concurrently.
Maybe they didn't want to pay
Maybe-
for him to be incarcerated here. The problem, though, is he's left languishing there through no fault of his own, to find out once he gets back here, he's
Wait a
not
minute,
getting any credit.
he wasn't left languishing. He was serving time on a New Jersey sentence, and if he served more time there than that sentence was, I think under our statute, he may have had to be given credit for that time here. But that's not the case here.
Well, that's if you looked at the that provision of the parole jail time statute, which is inapplicable in a situation where it's been a concurrent sentence that's been ordered. That would
Well,
apply.
that's if there's a concurrent sentence ordered by a New York court, not if there's a concurrent sentence ordered by an out-of-state court.
Well, there's no distinction in the statute about that. And so it was a concurrent sentence. It only makes sense to guard against that spillover provision, that they call it, if the sentences were run consecutively, because then there's a period of time you're trying to ensure that these sentences are being served separately. And in a situation where the sentence is ordered concurrently, there's no spillover concern to guard against. So here, the department could have acted on their warrant, brought him back to New York, given him, and they concede that they would have given him credit day for day, including against the PRS term, for any time that he served in New York. So merely because of how it was administered and where he served the time, he's being penalized and by nearly 4 years of time that he could have gotten credit if he'd only been brought back. And it's really through no fault of his own. And the burden should be on the department. If they really have an interest in having him serve the time in New York, they could have acted on it and brought him back. And they did not do that. And I see I'm out of time.
Thank you, counsel.
Thank you.
Counsel?
Your Honors, and may it please the Court, New York has always had the authority to administer New York penal sentences. But on petitioner's theory, New York would have given up a large portion of that authority to its sister states, and in this case, as
Counsel,
Judge-
what's your position as to what the New Jersey court ordered? What were they running, or what did they say they wanted their sentence to run concurrent against?
Well, as we read the New Jersey court order, the New Jersey court didn't actually order its sentence to run concurrently with petitioner's undischarged PRS term, which would be, I guess in colloquial terms, the sentence underlying the PRS violation than the imminent PRS violation. But what the New Jersey court said is that they wanted the New Jersey sentence to run concurrently with the sentence imposed on the PRS violation. Now, the sentence imposed on the PRS violation is not the underlying undischarged term, but it's the time assessment. And arguably, that's exactly what Docs did, because strictly speaking, the time assessment, as we point out in footnote 4 of our brief, was styled as for 71 months, but it was backdated as of 2011 when the parole warrant was issued. And so all that time he was in New Jersey custody, Docs allowed him to essentially tick away on that 71-month time assessment.
But if that's what if that's what is determined that New Jersey court intended to do, then is there anything left to decide on this appeal?
No, we think that's a full alternative ground for affirmance in this case. But I do want to hit I think the statutory interpretation question, because Doc certainly wants to be heard on that. Petitioner's PRS was interrupted. It was not running during the entirety of the time when he was in New Jersey custody, which means that the only way that obligation, the PRS obligation, could be reduced is through an award of credit. Now, if you look at the PRS framework, such credit, in this case, could only be awarded, as your honors have pointed out in your colloquy with my friend on the other side, under 70-40, sub 3, sub C, sub I. Petitioner says that there's an exception to that exclusivity where you have a concurrent sentence as opposed to a consecutive sentence. There's no textual basis for that exception in the PRS framework. In fact, in the PRS framework, it says that, quote, any time spent in custody, it's intentionally broad, is evaluated through that prism. And there's no dispute that that provision itself does not afford the PRS credit at issue here. Now, petitioner mentioned these lines of lower court cases, again, in the New York order, the New York sentencing order context, that purport to require docs to enforce orders directing a subsequent sentence to run concurrent with a prior interrupted sentence. In the penal law language, that's kind of like dividing by zero. There's just no machinery to do that under the penal law. By definition, concurrency can only be achieved with a sentence that is running. So with respect, I mean, this court has never passed on that issue. We think that exception, if you will, is wrongly decided by the lower courts. There's just no statutory basis for it. But even embracing that exception to the extent that lower courts like Campbell and Midgley did, the exception simply doesn't apply here. The way the lower courts were able to carve out that exception was on the basis of New York courts' inherent authority to direct the operation of New York penal sentences. We don't have that here. We have a court of New Jersey. New Jersey does not have that same inherent authority, does not have any inherent authority over administration of New York penal sentences based on the equal sovereignty doctrine and the like. And as far as fairness goes, you know, freestanding fairness has never been a dispositive criterion for awarding credit against in this state anyway, against an interrupted sentence. There has to be some affirmative statutory basis or some overriding constitutional command or the like. We don't have that here. But let's look at where the fairness interests lie. Let's look first at petitioner's circumstances. He was counseled at the New Jersey sentencing hearing. The Howard case from the 3rd Department at that time had been on the books for a year. And that case basically counsels people in petitioner's circumstances to ask for, do something, make yourself known to get the state of conviction, of subsequent conviction, to work with the executive authority of the previous state to send you back to get that credit. Howard had been on the books, but there's no evidence that petitioner asked the New Jersey court or the New Jersey Department of Corrections or anyone in New Jersey to arrange for him to serve that sentence in docs. Now, we think that's enough to mitigate any unfairness concern. But again, we're dealing with PRS here. And PRS, although in some ways similar to parole, it's also subtly different. PRS was enacted as part of a Get Tough on Crime statute, Jenna's Law, in 1998. So if you're going to break ties with fairness, we certainly think that there's a reason to do so in favor of a strict interpretation of PRS credit as opposed to a permissive interpretation.
Let me ask this. Are you familiar with Eiffel? It's the Third Department
Sure.
case, 2017. The way I read that, it seems like the state expert there, who's the same expert as here, said that parole jail time credit can be ordered to run concurrently with PRS violation by a New York court. So do you reconcile it by simply saying that a New York court can do that, but New Jersey court can't?
Well, if we had to reconcile it, that's how I would reconcile it, that New York gets to that, the docs attorney in that case got to that result by, not through the language of the penal code, the penal law, but really outside the penal law and through New York courts'
The
inherent
court's authority would trump the penal law authority.
Exactly.
I think that's what the situation of our jurisprudence is. So that's how you reconcile his statements in Eiffel with his testimony before us today.
Well, the answer is yes to your question if I had to reconcile it, but I do want to push back on your premise. With respect, as we see it, that's not this court's jurisprudence, that's the lower court's jurisprudence. The expert in that case, the docs attorney, was citing Campbell and Midgley and the like. Those are lower court cases from the Third and Fourth Department. Now, to be sure, this court has said in cases like Garner and Sparber
I was going to say, it seems that that principle has been pretty well enunciated and established by this court. Not in this circumstance, but the principle itself has.
Well, we don't think we need that to win here, so I don't want to quarrel too much with it. But again, even in the Garner and Sparber case, there the court did not approve the sort of dividing by zero that you'd have to do in order to get.
These mathematical analogies, you're losing me. I'm just telling you, you got.
Well, sometimes the lower courts lose us, we think, with this. But Garner and Sparber just say, docs, when you are presented with a definite sentence that does not have a PRS term attached, you have to implement a determinate sentence, rather. You have to implement that determinate sentence.
So let me ask
written.
you this. We've got a little time left here. What do you think about the fairness argument?
Well, I'd like to get to the rest of the fairness argument. I think the fairness argument certainly does not cut in petitioner's favor.
No, but
even
really?
Really, Your Honor.
Tell me why.
I think it doesn't cut in petitioner's favor for the reasons I was discussing before. The fact that he was counseled at the sentencing hearing, these cases were on the books in terms of this is the procedure to ask for. But also, fairness, there are two sides to the fairness coin. There's fairness to petitioner, but there's also fairness to the sovereign interest of the state of New York in controlling how petitioner pays his debt to New York. And that would be completely subverted here. But in any event, this court has never recognized, and we think the appropriate standard, as we point out in our brief, and the other side didn't dispute in its reply brief anyway, is that there has to be a clear command.
The real issue is you have a New Jersey court, and they're the ones who are deciding whether or not they want the time to be concurrent or consecutive. And when they've made that intent clear, let's put aside your first argument,
Right,
I understand your
suppose they
first
did.
argument,
Sure.
but let's just say with this alternative argument. Once they've made that clear, you may have other arguments about fairness, but we can't say there's not some part of it that seems unfair, because that's their sentence, and they've decided they want it to run day to day with the New York sentence.
Oh, but Your Honor, for New Jersey purposes, if this case had arisen in New Jersey,
Right.
New Jersey, in its own courts for New Jersey purposes, could interpret this as day-to-day running. We are not dictating how New Jersey, in its own courts, in its own administrative system, controls how petitioner pays his debt to New Jersey. We are saying.
Right, but I thought where you end up is because of an administrative, because of administrative issues, he ends up not getting, for the moment I'll call it the benefit, of that New Jersey court's intent. And that's where the unfairness lies.
Well, we don't see it as administrative issues. We see it as that's what the legislative scheme dictates.
Could the New Jersey court have ordered sua sponte, the return of the defendant to New York, to ensure that it ran concurrent to any sentence that New York imposed?
The New Jersey court certainly could have tried to do that. I think New York
Have to agree.
I think New York would have to agree. New York is part of the Interstate Corrections Compact, as is New Jersey, so I think there's good reason to think that they would agree. And if you look at the cases, and I'll just say this before I sit down, in footnote 6 of our brief, where we collect when this happens in other states, you do have examples of courts ordering defendants sent to other states to serve out terms like this. Sometimes they're accepted, sometimes they're not. That would present a set of different issues, but this is not a unicorn type of issue. This
So your
happens.
position is, no matter what the New Jersey court wanted to do, it couldn't necessarily actualize that?
It couldn't control, yet the answer to your question is yes, Your Honor, the New Jersey court could not control New York's administration of petitioner's New York penal sentence, and we'd ask that the court below be affirmed.
Thank you, counsel. Counsel?
Yes, Your Honor. There's at least 2 points that I'd very much like to respond to. One, as to what the New Jersey court intended, that it intended its sentence to run concurrently with the underlying New York sentence that time owed here in New York, I think is beyond dispute. Despite raising doubts about that, both the Supreme Court and the Appellate Division made a factual determination already about what the New Jersey court intended, and it's never been in dispute from the beginning. And most importantly, Mr. DeSimone, who is the head of Office of Sentence Calculation, he worked from the premise as well that this is what New Jersey intended, and all the arguments in this case have been developed with that premise in mind. So it would be very unfortunate for the case to not even be decided after coming this far on that factual question, which I don't think is genuinely in dispute. The other point that I feel important to note is that the indefinite sentence cases, which docs litigated or made prisoners litigate to get the credit for some 40 years, they uniformly lost, to my knowledge, without exception, throughout the Supreme Courts, in the 4th Department, the 2nd Department, and the 3rd Department, beginning in the 1970s, right up to 2011, and then finally in 2013, docs conceded, all right, we'll give this credit. And those cases were really tethered to the idea that the underlying New York sentence had been interrupted, and it was a fiction that it couldn't resume until they returned to doc's custody. But those definite sentence cases is a typical scenario where the individual would serve that time in the county jail before coming back to doc's, when this idea that the sentence would then resume. And that credit was given in those cases. And the Howard case is an aberration, and we specifically pointed out the conflict between Howard and that line of cases and doc's reasoning, and unfortunately the appellate division below didn't address that, and simply echoed its language from Howard that it was incumbent that he return to New York without acknowledging the arguments and explaining why that was the case, without any elucidation about that. And we really feel that conflict, this court has an opportunity to resolve that conflict here, and it's really to perpetuate this fiction that because the sentence was interrupted, they couldn't get any credit for that. It just doesn't make any sense. And that it's not parole jail time that's at issue here. It's concurrent sentence credit. And there's an entirely different statute which explains, 7030, how docs is to calculate a sentence involving a concurrent sentence, whether it's a New York sentence or any other state sentence. And so the exclusivity argument about the PRS statute being on PRS instead of ordinary parole, somehow altering that and being an exclusive remedy, that this isn't parole jail time to begin with. And secondly, it doesn't even address the question that that spillover provision of 7043C3 really only makes sense if it's a consecutive sentence and not a concurrent sentence.
Thank you, counsel.
Thank you very much.